Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back. I hope everybody's having a fabulous Friday. Today is November the 14th. What are we going to talk about today? Well, as promised, we are going to go ahead and see the competency hearing of Brian Walshe. We've been talking about Brian Walshe for a couple of series now. So if you are new to this channel or new to this case, let me just give you a brief update about who Brian Walshe is. It'll be brief. Brian Walshe versus Massachusetts. Brian Walshe lived in Cohasset, Massachusetts. He was married to Anna Walshe. Something happened to Anna Walshe on January 1st of 2023, I believe. January 1st, 2023. They had a dinner with a friend and were celebrating the new year. A couple of days later, January 3rd, Brian reports Anna as missing. Comes to find out that through some investigative police work, which is a little bit questionable, we went over the evidentiary hearing in reference to how did the police find out some of the information that they did and whether or not that information is going to come in at trial. Spoiler alert, it's coming in. That they downloaded the information off of his phone and found out his location data, which was nowhere near where he said he was at. Long story short, they went and looked in dumpsters in those areas and found some of Anna's belongings. Is that enough to convict him? What other evidence do they have against him? Now, a couple of other things is that Brian Walshe is going for a competency hearing today. And why is that important? There was an incident in jail where he was stabbed in the neck. He claims that that has affected him. So the judge had no alternative but to go ahead and put a hold on his trial and have him go for a competency hearing to find out whether or not he is mentally stable in order to continue with his trial and to help out with his lawyers in his case. So that is what we're going to watch today. Then we're going to get updates on his case. Are we moving forward? Are we putting things on pause? What is happening in this case? So today, buckle up. We're going to watch this coverage. I haven't seen it myself, so we're going to watch it together and we're going to react together and see how things have unfolded. So here we go. I'm going to add this to the stage. So luckily we had Boston 25 covering it. I don't know how this is going to go. So this is how these things end up happening. So again, if you're new to my channel, please put a like and subscribe to my channel. I am hoping to get to a minimum of 50 subscribers by the end of this month. When I checked yesterday, we are at 12. So let's keep going. So if you like this content, subscribe. Here we go. A little bit here. Don't mind me tappity tapping. People coming into the courtroom. Oh boy. Well, I apologize. I should have started where we thought things were going. All right. We got some movement in the courtroom. Let's see. And I don't know how the sound is going to be, so hopefully it's going to be okay, and we'll figure things out. I can hear Judge Frenier. Uh-oh. They must be at sidebar talking about some stuff. Still at sidebar. Well, I apologize. I should have queued this up to where we were.
A few things on my agenda. The first one, which is with regard to the defense with that finding, which I accept.
Oh boy, you can barely hear it. Well, you might have to turn your volume up on your computer. Okay.
As I said to council. All right. So, welcome, as I said, to council, and welcome to Mr. Walsh. I have a few things on my agenda. The first one, which is over here, is the competency. I've now received a report from Bridgewater State Hospital, comprehensive report from Dr. Ryan. And in that report, Dr. Ryan concludes that the defendant is competent and ready to stand trial. And with that finding, which I accept, had a brief conversation with the side of the bench. What's the defense's position? I just want it on the record, on the public record, with regard to the defendant's competency.
Two things. One, we're not contesting the competency. Two, we had conferences with other groups. We had them last month. What he asked us to do is he is concerned that changing the right to the jail may have an adverse effect on this report. He wants us to provide us and ask us to come to court with concerns about that. He said that's not his lane. But we do. We want to let the court know that we have those concerns, and we'll bring it to the court's attention as soon as we think they might be posing a problem. We're also informed we should hear it from the facts. But other than that, we're not contesting.
All right. As with any case, and any time, in my experience, the defendant goes to Bridgewater and then is returned to the facility, there's always a transition period. He's been there for 40 days now and has gotten, as I understand, into a routine. And that routine is going to be changed as he moves back to the House of Correction. So understandably, there will be some transition period, and you and alerting the facility knows this, they deal with this quite regularly. But I understand your intent to alert me to it, and we'll have some time here, I believe, between the time that we're picking a jury in this case and the time.
Okay, I'm going to pause it there. I could barely hear it. And as you saw, the court reporter, court officer came by and was like, talking to the microphones because no one can hear you. What I'm thinking, I'm suspecting, again, speculation, what he said was, I feel like since Brian Walsh was in the Bridgewater State Hospital, he was used to certain things. He might have some sort of special needs that he needs to have met, being moved from the mental hospital, the hospital to a facility. And so I think that Larry Tipton was asking for, I don't want to say special treatment, but special things that Brian is going to need as he transitions to the correctional facility, probably some special things to help with his mental stability while he's going through this. Again, he is alerting the judge. The judge can make some orders or some determinations or some recommendations, but she doesn't control the jailhouse. So that's my speculation. Let's continue.
I'm not suggesting that you're not working at that time, but the defendant's role in that is significantly different than it is when we're actually actively engaged in the trial. So hopefully that'll give him a nice time to settle back into the House of Correction. But obviously, if at any point you become concerned about that, I know you won't hesitate to raise it with me. All right. So, let me, and I discussed this with you at this side of the bench as well. I received some edits from the defense to the questionnaire, which I will incorporate into the next version of the draft questionnaire. It's always a draft until the minute.
Okay, we're going to pause right there. She is talking about the questionnaire, and this is the jury questionnaire, right? In order to be a person on a jury, you have a few questions that you have to answer. Probably, do you know anything about this case? Are you biased one way or another? Whatever. So jurors fill out this questionnaire, and then they do what's called a voir dire. They ask and answer questions, and then they seat the jurors. So if they are at this stage where they are doing a questionnaire of the jury, my guess is that this is going to happen sooner than later. But let's continue to see what Judge Vernier has to say.
That I finalize it and send it to that pool of jurors. Speaking of that pool of jurors, somewhere on my desk, I have the updated numbers. Who knows what the yield will be, but I expect to take about 70, if I can, 60 to 70 jurors a day. In my experience, it's hard with the questionnaire, even without doing all the copying, to get through more than that number in a day. And there are other cases that are starting on Tuesday. And so if we can accommodate those, we will. We'll have to see what the draw is. The expected number is 105 now for Monday, and we're going to hold those over to Tuesday because, as you know, we're doing the final trial conference on Monday, and then we'll start the empanelment on Tuesday. So it looks like 105, 126, 121.
Okay, so let's pause it there. So I'm looking at the calendar. She is saying that the final pretrial conference is going to be on Monday. So they're starting Monday. So they're going to have their final pretrial conference on Monday. That's where they'll go through any last motions and stuff that either the defense or the prosecution has. They're going to go over what they call getting things set up, how are things going to run, etc. And so that's going to start on Monday. Wow. Okay, so this is happening, people. This is going to happen next week. Whoa, this is going to be interesting. Let's continue.
68 on Thursday, but those people will be pushed and held over till Friday. So we'll have a full group of some number of people to work with in getting a jury next week. And then jurors are here.
Okay, so she is saying that there's a pretrial conference on Monday, the 17th, and that they hope to go through picking a jury from the 18th through the 21st. So if they plan to do that and a jury is selected, the following week is Thanksgiving. So I'm wondering if this trial is going to start the first week of December. Ooh, let's continue hearing.
Also on Monday and Tuesday of the following week. And I think we're the only game in town. That is, I don't think anybody else is paneling on Monday and Tuesday. Our intent is.
Oh, I should probably stop pausing. I should probably just wait for her to say things. So she is saying that court's still going to be in session Monday and Tuesday of the week of Thanksgiving. So she is holding over things she's ready. She wants to pick a jury. So, wow. Okay, so I got to write down those dates. All right, here we go.
If we get a jury during that allotted time, we will start the trial, the substance of the trial, on 12/1, Monday after the Thanksgiving holiday. Everybody on board with that schedule? All right, good. Let me next address, and then once I do this, I'll certainly turn it over to you. We're going to have our formal, really today's purpose was to address the competency, but to the extent that I could pick off issues that aren't technically motions in limine, but other important motions to the parties, I focused on those today. And I am prepared now to make a ruling on the change of venue paper. That's paper number 219, and I'm going to read that into the record now.
Okay, so I'm going to pause it there. Obviously, I mean, you could read the room, right? Obviously, she's not going to have a change of venue. If they are getting ready to pick a jury next week and that they are getting ready to start trial December 1st, There's no way she's changing the venue. So but she has to make a record of it, right? She has to put her ruling on the record. So she's going to read that and state her reasons why she's not changing the venue. So, I mean, spoiler alert, hello, you can read the room. She's not going to do it. So let's continue.
Mr. Walsh has moved for a change of venue on the grounds of extensive and prejudicial pretrial publicity that he asserts has tainted the jury pool so as to deprive him of his right to a fair trial by impartial jury. Alternatively, the defendant seeks an order that prospective jurors be selected from outside of Norfolk County. In support of his motion, the defendant has submitted evidence of extensive national and local media coverage of the case, beginning on January 6, 2023, after Anna Walsh was reported missing, and continuing till the present day, as well as evidence of social media engagement with this case. After careful consideration of the defendant's motion and the exhibits provided to the court, I'm denying the motion and the request for alternate relief for the following reasons. The court may order a change of venue where there exists, quote, and it exists in the community where there is a prosecution is pending so great a prejudice against the defendant that he may not there obtain a fair and impartial trial. And that cites back to Massachusetts Rule of Criminal Procedure 37 and Commonwealth versus Clark, 432 Mass 1 at 6, a 2000 case. A judge has substantial discretion to transfer a case to another county based on pretrial publicity. And according to Commonwealth versus Gaynor, 443 Mass at 245 at 259, pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. A change in the place of a trial should be ordered with caution and only after the defendant has established, based on a, quote, solid foundation of fact, that the pretrial publicity has created presumptive prejudice. And to that I cite to Commonwealth versus Hart, 493 Mass 130 at 141, and Commonwealth versus Tulin, 460 Mass at 452, at pinpoint site 462, 463, a 2011 case. Presumptive prejudice exists only in truly extraordinary circumstances where the trial atmosphere is utterly corrupted by media coverage and, quote, the entire venire may be presumed prejudiced regardless of specific voir dire procedures utilized. This standard is only met if the publicity is both extensive and sensational. And to that I cite to Commonwealth versus Who's, 467 Mass 395, 406, a 2014 case. In assessing whether pretrial publicity precludes a fair trial, the court should consider additional factors such as, quote, the size of the community, the length of time between the peak media coverage and the date of the trial, and whether the news stories contained a confession or smoking gun rather than merely being unkind portrayals of the defendant, end quote. Commonwealth versus Garhut Strider, 82 Mass Appellate Court 500, 506, a 2012 case. The defendant here contends that transfer of his case out of Norfolk County for trial is necessary because the nature and extent of the negative pretrial publicity his case has received has encouraged a bias and prejudice against him in this county. Having reviewed the numerous materials submitted in support of the defendant's motion, I conclude that presumptive prejudice has not been shown. Although the media coverage has been extensive and somewhat graphic due to the nature of the crimes charged, it has also been primarily factual, describing the events in question, the charges against the defendant, court proceedings in this case, and the defendant's criminal history. Quote, fact-based publicity, even that which contains references to charges pending against the defendant or a prior criminal record, is not the sort of sensational publicity that would give rise to a presumption of prejudice, end quote. And that's who's at 467 Mass at 407. The publicity in this case peaked in January 2023 when the defendant was charged in connection with the victim's murder, and has decreased in frequency over time, undermining a presumption of prejudice. Again, who's at 406 and Tulin at 460 Mass at 465. Notably, nothing in the defendant's submission addresses whether the pretrial publicity has been more extensive in Norfolk County or the likely number of potential jurors who were actually exposed to the media coverage. Moreover, other factors weigh against a finding of presumptive prejudice. The trial is scheduled to take place nearly 3 years after Anna Walshe was presumed dead, and therefore there has been a substantial amount of time between the initial media coverage and the selection of the jury. Indeed, much more of the recent media coverage is focused on court decisions leading up to trial and the status of the case. Further, the defendant has not shown that there has been any report of a confession by him or any like evidence. See Gerhardt's writer, 82 Mass App Court at 506. And unlike other cases where the small size of the community weighed in favor of a finding of presumptive prejudice, for example, in Nantucket County, given the size of Norfolk County, the defendant has not shown a high likelihood that the entire jury pool would be tainted by the pretrial coverage of this case. To that, the court cites to Commonwealth versus Leahy, 445 Mass, 41 at 493, 494, a 2005 case. Defendant's motion relies heavily on evidence of negative social media posts presuming his guilt. There is, however, no indication that any of the posts were made by or read by Norfolk County residents, and thus they do not present a compelling reason to transfer his case to another county. In sum, while the defendant has demonstrated that the national and local media have extensively covered his case, he has not demonstrated the, quote, type of emotionally charged, inflammatory, sensationalistic coverage needed to support a presumption of prejudice, end quote. United States versus Angulo, 897 F. 2nd, 1169, 1181, a First Circuit case from 1990. Nor has he shown that there exists in this community a prejudice so great that he cannot obtain a fair trial in Norfolk County. Thus, I will not now order a change of venue. Alternately, the defendant has requested that prospective jurors be seated from outside of Norfolk County and transported to Norfolk County Superior Court for trial. Quote, such an order ought not be given lightly. Commonwealth versus Aldopoulos at 390 Mass, 438, 448, 1983. The defendant must, quote unquote, fully establish the reason why a foreign jury is, quote, necessary to further the administration of justice. The defendant's motion falls short here. The defendant has not specified in his motion why he cannot obtain a fair trial with jurors from Norfolk County. He has not, for instance, shown that the media or social media coverage has been more widely viewed by prospective Norfolk County jurors as opposed to residents of other counties. That engagement with social media postings about his case has been higher by residents in this county, or particularized his evidentiary support to the residents of Norfolk County in any way. Merely explaining the widespread coverage of this case in the greater Boston area and providing examples of negative social media posts from unknown users is insufficient to establish the necessity of a foreign jury. Any concerns as to the impartiality of prospective jurors from this county due to pretrial publicity will be addressed by this court with careful and thorough voir dire and is always subject to reconsideration by this court. Accordingly, the defendant's motion for a change of venue or alternate relief is denied without prejudice. The defendant may renew his motion, and the court won't hesitate to re-examine its own decision should the impanelment of an impartial jury prove impossible as a result of community prejudice. So there's one other matter that I want to address.
So there you have it. She explains why her decision is that he doesn't get a change of venue. Change of venue is when so he's being charged in the county of Norfolk, Massachusetts, because that is where he resides, and that is the district with where they have the higher court. They wanted to change it and move it to somewhere else. That's what change of venue is. And she is saying that they can remedy any sort of prejudice from the media via the questions that they're going to ask in their voir dire, meaning the questions they're going to ask the jurors, whether or not they heard about the case, et cetera, et cetera, et cetera. Now, jurors can lie, right? They're not supposed to. You're not supposed to lie. You're supposed to be honest. You're supposed to state the truth, et cetera. You're not supposed to lie just to get on a jury, but it happens. It really does. And unfortunately, the judge, the defense, the prosecution, they don't know if you're lying. They do sometimes hire private investigators to do and go and search about you as a juror to find out, kind of who you are. That's not uncommon. I would say that he has had a lot of publicity in this case, and it continues to spiral as we talk about Proctor and Proctor's texts, what is and isn't going to come in and out of this trial. And we'll go over that in just a minute. So every defendant has a right to a fair trial, right? And if you have a juror who is biased against you, right? Like they have already predetermined that you were guilty before they even heard any of the evidence, which is completely wrong. You as a person, you as a juror, you are the finder of fact. You're the one that is supposed to listen to all the evidence and determine afterwards if you feel like it is the prosecution's job beyond a reasonable doubt to let you know that he is the person that had committed the crime and that there was nobody else, there's nothing else, etc. It's Gary Tipton's job as the defense attorney to poke holes in the prosecution's theory and create doubt for you. And if you have a doubt that is, you have questions, you have doubts, you don't think that the evidence adds up to him, then it's your job to then find him not guilty. Or there sometimes might be some lesser charges that you can attribute it him to. Again, I'm not 100% sure what his charges are. We'll find that out once we get into the trial. I can look it up, but it's okay. You'll figure it out. So let's continue on and see what she has to say about what else she's going to cover. By the way, there's an airplane taking off. If you hear that noise, it's me. It's not you.
With the lawyers, and that will take place at the side of the bench. But before I do that, are there other matters that it's important for the parties to raise today, recognizing that we are going to have the final trial conference on Monday? Bless you.
One quick one, Your Honor, was I know that Mr. Tipton had a hearing on 12/9. I didn't know if the court was going to break for that at 2 o'clock.
Oh,
I was going to ask this side of the talk about that briefly.
all right. Anything else?
No, that's it.
All right. Anything from the defense other than what we're going to discuss at the side of the bench?
No, and the only other thing is I just want the record reflect that we object to the court's ruling.
Certainly will. I understand. All right. I'll see you at the side of the bench.
Okay, so there's a couple of things that just happened there. The prosecution stood up and said something about there's a conflict with Mr. Tipton. He's got another trial on December 9th that's going to kind of throw a wrench into the middle of the Brian Walshe trial. And what they'll probably do is pause for the day and just say the jurors and everybody have the day off, or Mr. Tipton might resolve that case. Sometimes cases get resolved in the meantime. And the same thing could happen in the Brian Walshe case. It can be resolved, meaning there can be a plea agreement, and that this everything that they've gone through thus far gets moot. They wash their hands of it and they just say he's going to plead to whatever. And that can happen. Can happen during the middle of the trial, can happen at any point in time. But most importantly, again, in the process of a jury case, Mr. Tipton got up at the end and said that he wants to note an objection on the record, and that he objected to her decision of changing a venue. And it's just for him to preserve the record, because even though once the jury trial happens, and if Mr. Walshe is convicted, remember, he is proven innocent. He is innocent. All these charges are alleged until it is presented in court and a jury finds that he has been proven guilty. If Mr. Walshe is found guilty, most defendants have the right to appeal their case. And what that means is that they have the ability to then bring it to a higher court, the appellate court. There has to be a reason as to why he's basically claiming he didn't get a fair trial and he wants a new trial. But every defendant usually has an appeal. And so Mr. Tipton is reserving his rights for the appeal. Could it be that they could say, "Oh, Judge Fernier was wrong. There was a tainted jury pool, and she was mistaken." That could be one of the reasons as to why he's appealing his case, and state that she had it wrong. So he's just making it for the record. So let's continue to see if there's anything else that they're going to put on the record for the case. They're going to go to sidebar here, and we're going to zoom past. Here we go. All right, I don't see anything else. So this is just Boston 25's coverage of it. There might be something else, but this is what we have. All right, so let's do sort of a recap as to where we're at and what transpired today. So Brian Walshe has been found competent to go ahead and stand trial for the death of Anna Walshe. Remember, in our overview of the case, Brian Walshe was married to Anna Walshe. They had 3 children. On January 1st, 2023, it was the last time that she was seen and heard from. January 3rd, he then calls the police and says he hasn't heard from her. They obviously do lots of searches for her. They even go to Washington, D.C., because that is where she has her job, at Tishman Speyer. They don't locate her. The police get an agreement to get his devices. They download the data off of there. again, so that you want to talk about an appeal. So that is one thing that once his case goes through, and if he is found guilty, that is definitely something that they can bring up upon appeal, whether or not the police had the right to download all of his devices. And that could be grounds for an appeal. Depends on how the appellate judge sees it. But in Judge Frenier's case, she said, no, it's not fruit of the poisonous tree. They would eventually have found the information. So it comes in. And in that, they found some data location from him. He said he had gone to Whole Foods and Walgreens in and by where his mother lived. They found that that is not true. So then they went to those locations. One was Home Depot. They found surveillance cameras of him buying a lot of cleaning supplies in between January 1st and January 3rd. Then he also had some data location of him being by some apartments, etc. So the police went into the dumpsters, and in one of them they found some stuff that belonged to Anna Walshe. Do all of these things add up to him unaliving her? It's to be determined what evidence is going to come into this case, and you, as a juror of the facts, will see whether or not there's enough information that has come to light as to whether or not he is guilty. So we don't know all the evidence that they have. We only know some information that they've brought into via the pre-trial hearing motions, and that some of that I have just laid out for you. But again, I'm not a lawyer. I just read what has been out there and I hear what's been out there. So you get to find out whether or not he is guilty. So they are going to go ahead. So next Monday, the 17th, is going to be the pre-trial hearing motions. They're going to go over any last motions that they have. They're going to probably talk about the juror questionnaire. Then they are going to start jury selection on November 18th. They're going to continue the 19th. They're going to continue the 20th. I don't know about the 21st, which is Friday, so I don't know if they're going to continue that day. But she did say that they are also going to continue the Monday and Tuesday before the Thanksgiving holiday, the 24th and the 25th. Now, when it comes to jury selection, we as the public don't get to watch that. We don't get to hear the questions, et cetera, et cetera, et cetera, because jurors are supposed to be not necessarily anonymous, but their identity isn't supposed to be known to the public. So we don't get to watch them question the jurors, et cetera. We just know when a jury has been seated. They do have people in the courtroom, and they do get to see this, but it's not televised. There'll be news people who will come out and let you know how many jurors have been seated when, et cetera. And I'm not sure if they're going to choose a jury of 8, but at some point in time, we'll know when a jury has been seated, completely seated. So each day there'll be a tally as to how many jurors have been seated, and et cetera. We don't know who the alternates are usually until the end of the jury trial, and then through some process, we'll find out who the alternates are. But as she stated, that they're going to continue to go through the jury process all next week, the 2 days before Thanksgiving, and then hopefully once a jury has been seated, trial starts on December 1st. Unfortunately, they didn't tell us how long the jury trial will be. So probably maybe on Monday, when we do the pre-trial hearing conference, we'll find out how long they suspect things will go. I haven't heard any smatterings of how long things will go. I was hoping to get something on the record today as to how many witnesses the Commonwealth tends to call, and then how many witnesses does the defense tend to call, and that can give you an idea of how long things will last. But definitely the judge will tell the jurors in the process how long they think this trial is going to last, etc. So I thought that we would do something kind of fun, and I thought that we would look up to see who is Judge Frenier, right? How long has she been on the bench in Massachusetts, and give a little bit of background as to who she is, because this is a learning process, right? We are learning about the judicial system. We're learning about how the court system is. We're learning about what evidence comes into court, what evidence gets out of, is not allowed in court, and why. Because you have to have receipts, right? So you have to have prior cases that have come through the process in order to cite them as your proof that things can and can't come in. Again, the judge also cited some cases as to why she thinks that there shouldn't be a change of venue. Larry Tipton later on can argue, well, it wouldn't be Larry Tipton if it was appealed. He is not an appellate attorney. If Brian Walshe does get convicted, he'll have a different attorney. That attorney will then cite cases, etc., that says whether or not Judge Frenier was accurate in her depiction of what the law was, whether or not he should or should not have had a change of venue. But, all right, so hang on just a second and let me do some typing. I'm going to put everything on mute so you don't hear my typing. We're going to pull up something about Judge Frenier, and we're going to go over that. Hang on just a second. Okay, this is what I found. So let's go ahead and let's add this, and we'll go over all of it. It'd be kind of cool. Thought it would be neat just to kind of see, who she is and what she's about, and kind of get an idea of, what she who she is. All right, so I don't know. Let me see if I can. Nope, that doesn't do that. Let's see if I can make this a little bit bigger. I'm not sure. Well, I'll read it to you. If you can't read it, I apologize. Okay, her name is Diane Frenier. She is an Associate Justice of the Superior Court of Massachusetts. Massachusetts. She was appointed to the bench by Governor Charlie Baker in 2017. So she's been on there for quite a while. Just remember that these justices in this district are appointed. They are not elected, which could be a problem. She earned her bachelor's degree in manufacturing engineering, wow, at Boston University in 1985. She spent the next several years as an officer in the United States Air Force, wow, holding assignments in the AFPRO, Hughes Aircraft Company, and at Edwards Air Force Base. That is so cool, right? And then she completed her JD at Boston College of Law in 1991. And as a law student, she sat as the articles editor for the Boston College Environmental Affairs Law Review. After graduating law school, she entered into private practice as an intellectual property litigation associate. She worked in this capacity until 1994, which at the time she joined the Office of the United States Attorney for the District of Massachusetts as an assistant U.S. attorney. She held assignments in the Economic Crime Unit and Healthcare Fraud Unit, prosecuting a wide variety of white-collar crimes. She also sat as the chief of the Economic Crime Unit and chief of the White-Collar Crime Section, and she served as a victim witness legal advisor. Wow. Then in 2014, she left her post at the U.S. Attorney's Office and returned to private practice. She became a counsel for the Zuzman Frenier Compton, Mark Zuzman Frenier Compton, representing clients in complex business litigation until her appointment to the bench. She has membership in the Bar Association, Boston Bar Association, the Massachusetts Bar Association, the American Bar Association. She has been involved with the National Charity League, the Wellesley Club. If you ever been to Wellesley, and something with St. Paul Church. She was born in Natick, Massachusetts, and is a resident of Wellesley at the time of her appointment. So that is a little bit about her. That is pretty interesting, right? So let's pause and let's see about Larry Tipton, who is Brian Walsh's attorney. So let's see if we can find a little information about him. Hold on just a second. Wow, I am not finding a lot on Mr. Tipton. If I'm just looking at things, um, there's not like a write up on him, which I'm really surprised. Very interesting. So I'm not really finding very much on him, except for he's a public defender. So a distinguishing factor for Mr. Tipton is that he's a public defender, right? When you get charged for a crime, let me just change this. Let me get rid of that. So when you get charged for a crime, right, they read you your rights when you go to, when you get charged. And they say, if you can't afford an attorney, one will be appointed to you. So you have to go through what's called an indigent stage. You have to prove that you can't afford an attorney. So apparently Brian Walsh can't afford an attorney, so one is appointed to him. And I don't know if they appointed Larry Tipton or Larry Tipton took him up on his case. I'm not sure. So I want to just get a little bit about who Mr. Tipton is. And there really isn't much. It says that he is a Berklee College of Music grad. He got a BA in 1981, and then he attended Northeastern University in 1988. So that's really interesting. I wish I had a little bit more information on him, but it's not coming up clearly as to what his background is. Let's see. It says social library. Okay. No. All right. Anyways, we'll just stop it there. Don't want to bore you with me looking up stuff, which I should have been a little bit more prepared, but it's okay. So let's just go back and let me share this with you about the Anna Walsh. All right. So we need to update our slide a little bit, but I just want to remind you that the other day we went over the evidentiary hearing of who these investigators were. They're the same investigators that were in the Karen Reed case. Again, the Massachusetts State Police gets called in when there happens to be a suspicion of a death. They then are the ones that investigate it. There's been some controversy in Karen's case about these investigators. A lot of them have been rehomed or removed or changed, and even Mr. Proctor has been fired. So we're going to talk about Proctor for a second. So we keep bringing him up, right? So again, we do know for a fact that some of Proctor's texts in the federal TUI dump in Karen Reed's case, remember the feds were investigating something, we don't know. They received text messages from Michael Proctor. Don't know how, we don't know how or why, we can only speculate. But in those texts, they knew it was exculpatory to Karen Reed's case. So the U.S. District Attorney or the U.S. District Attorney, Josh Levy, I believe his name was, said, in all good consciousness, I can't let this material just sit there. It needs to be given to both the prosecution and the defense. Again, some of the text messages were very demeaning and derogatory and were biased against Karen Reed and in Michael Proctor's investigation of the death of John O'Keefe. We do know for a fact that there is something exculpatory in those messages that is towards Brian Walshe or Anna Walshe. We don't know. If you recall back, the Miles King, Johnson, a couple of other people, including Brian Walshe, were fighting hard to get that federal material. They eventually got it. It took all of the month of October to get it. So Larry Tipton, Brian Walsh's attorney, has that information. What it is, we don't know. Hopefully it comes out in trial. So we'll find out there. But again, back in the end of October, Judge Krupp said that the Michael Proctor's text messages and information on his personal cell phone should be downloaded. And remember, there's thousands and thousands of videos, photos, text messages, emails, etc., that have been discovered. And unfortunately, we don't know what exculpatory information is in those messages, whether or not it pertains to Brian Walshe. So Brian Walshe will be the very first case where we'll see what information was in the federal TUI dump and what information came from his personal cell phone, if there is anything in that. So December 1st is a buckle up, because this one's going to be interesting to find out where Michael Proctor's stuff is going to come out and if anybody else is implicated in that. So Mr. Tipton is going to give us a good trial. It's going to be very interesting. So we went over all of this, what they alleged, and why could Brian Walshe have unalived his wife. It's possible that she wanted a divorce, and it's possible that she told him that night that things were going to be over. Life insurance is always something to think about, that she was going to leave and take his kids. And we do know that she was having an affair. She was involved with somebody in Washington, D.C. I believe that he is set to testify in this case, and we'll hear what he has to say, what Anna may or may not have divulged to him, especially the night that this incident may have occurred. Is there any telltale information in those messages? If there are any messages, don't know, speculating if whether or not she was going to reveal anything to Mr. Walshe. So we talked about what the legal arguments are going to be. We talked about the judge's ruling that the information is going to come in. So what's next? We already talked about that. So he is going to be competent. So that is all that I have in reference to today for Brian Walshe. I am going to go ahead and do another stream here. I did promise a Corey Richens update. So I'm going to get everything together and gather that information for you. And we'll do another stream on her. We want to give Brian Walshe his own time. So in case you wanted to get an update about that, and then we'll do Corey Richens next. There has also been an update in the Brian Kohberger case. The Judge Hippler has gone ahead and written an order about the restitution. I'll do a small blurb about that. That'll be in the shorts. So this has gone on for almost an hour. We're going to go ahead and stop here. Remember to like and subscribe. I am trying to get up to 50 members here. So do the YouTube things if you want to hear more content, etc. So we'll see you on the next one. Hope you have a fabulous Friday. Thanks for joining me. Bye. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.